All right. On this case, we are set for a discovery. Have you received all of the discovery?
The only thing we're still missing are records from Laurel Ridge. And I've been in discussion with them, and I think they'll be here any day now. I'm hoping. And then we're also actively negotiating a plea bargain that's going to require the presence of the other prosecutor who's absent today.
All right, Ms. Ferguson, I need a 30-day reset. This will be your final discovery date.
Judge, I think it's September 15th.
All right, September 15th, counsel?
That's fine, Judge. And if we do get it worked out before then, can we bring him back ahead of that?
Yes.
All right, thank you very much.
Do you have any questions?
No.
All right, thank you.
Have a seat, sir.
All right, thank you, Judge.
All right, let me see what, you're welcome. Joseph Matthew Juarez. Hello, thank you for dressing appropriately for court. All right, so what's the update on this meeting?
Your Honor, the district attorney canceled on me again. I do have an offer. I will tell you that my offer may change to defense. There is technically an offer that has been extended. I will say in good faith, I likely will change it once, but technically there's an offer, but I understand that the offer that is extended at this point is probably not something that's would really fit the understanding of the case.
All right, Ms. Ferguson, I need a jury trial date, and that'll be your plea deadline date as well.
Judge, we also informed by the state that they're probably going to be indicted.
All right. Norma,
I'd like that to get to trial before I have to correct that.
all right. Norma,
Yes, sir.
jury trial date and plea deadline date, please.
And I do have some with expert witness motions, Judge, although the state and I decided to confer and see if we could use their expert to get all the information without having to get another one
Okay.
to expedite the process.
Okay.
So we are being very diligent about trying to get this case done.
Absolutely.
September 15th.
All right. So September 16th is going to be your jury trial date. And Ms. Ferguson, if you can set this also for motions mid-August, please. All right. August 21st, the court will hear motions. Is there anything else?
Yeah.
No, Your Honor.
All right. Thank you. Once you sign the reset form, you're excused. Christian Alan Ruiz Garcia. Who's the attorney for Christian?
Me, Judge.
Oh. All right. So on the first, there's a motion to modify bond restrictions.
I think we resolved all that, Judge.
Okay. Yes, that has been taken care of. All right. So have you received all discovery?
And just in the case where there's multiple juvenile files, Duffy and I have been trying to work on it ever since the last time we were here. As you know, he's not here anymore. So there still hasn't been a resolution, and I think the state's position, not necessarily this prosecutor, but the juvenile prosecutor's position is they're just not going to do this. So
This is where things get sticky. Juvenile records, subpoenas, and prosecutors playing hardball. The twist? Juvenile files are some of the most protected under the law. Even when a judge asks, the other side can push back. The real question: will the subpoena strategy be enough to break through?
All right. So on the first, there's a motion to modify bond restrictions.
I think we resolved all that, Judge.
Okay. Yes, that has been taken care of. All right. So have you received all discovery?
But just in the case where there's multiple juvenile files, Duffy and I have been trying to work on it ever since the last time we were here. As you know, he's not here anymore. So there still hasn't been a resolution, and I think the state's position, not necessarily this prosecutor, but the juvenile prosecutor's position is they're just not going to do this. So
All right, so I thought we were supposed to have a hearing with them.
we did. And
Well, I know they were by Zoom saying they're not going to give it, but I said subpoena it.
we did. And I don't think their position hasn't changed. I don't care. They're basically telling the court, it doesn't matter what you tell us, we're not giving you.
Oh, yeah, we'll see about that.
Yeah. But we're trying to get around that problem by seeing if we can resolve some other cases, and we've been exchanging information and trying to get there. So I hate for us to spend way too much time on that issue if there's nothing resolving this. And Mr. Garcia just got indicted 6 weeks ago, Judge, so I think we've done a lot of work in a very short time in these cases. I've shared information with the state today for the first time that they didn't have before, in the hopes of helping them evaluate their case.
Okay, I'm trying to find this in my notes. Just 1 second. All right, so I would suggest file a subpoena and subpoena the documents, and they'll have to file a motion to quash, and we'll have a hearing, and they'll have to rehear.
Okay, Judge, can I have a week or 10 days before I do that so I can make sure that there's not a way we're going to resolve it and avoid that?
Sure, we can recall it for,
I'm sorry to.
yes.
I think because I can't make an informed decision without having those documents either. And I mean, I've tried to facilitate between this subsection of the office and that subsection of the office, and even in other cases, they just won't provide me with the discovery. And so I think that the hearing is needed because I can't really make an informed decision on these cases without having that discovery.
And Judge, it seems like, and I'm fine with that, us having that meeting, but records as a matter of law are just not open records. I can't subpoena things that.
No, I understand what you're saying. They'll have to file a motion to quash. I mean, people, you can file a subpoena on whatever you want to subpoena, and then people will respond to it with a motion to quash, and you can let them know that they're not allowed to appear by Zoom, so they'll have to be in court. We can get conversations started.
I'm anticipating them telling me, you can't get those records. Why are you subpoenaing them? I'm going to tell the judge so too.
But I mean, we do things legally, and legally they'll have to file a motion to quash, and they'll have to come in and have it heard.
I understand that, but
Yeah.
there's also this idea that I shouldn't be filing motions that I don't have a good faith belief that I could even get, right? And obviously I don't have a good faith belief I'm going to get anything. I know I'm not going to get anything, but I will do it because the court's asked me to do it.
All right. So we'll be back on, because who knows, they'll show up and maybe they can tell you all things as opposed to giving you documents. So we're going to come back on August 21st for motions. All right.
Thank you.
Thank you. Who's here on Freddie Gonzalez?
We are doing. We're three appointed attorneys.
All right, come forward.
There's 3 clinic and 1 hired. So all of the bill, I don't know where he stepped out to, Judge.
And which case is he the attorney on?
We wanted to see if the court would just appoint 1 attorney on the appointed cases. To avoid any confusion.
Page 5, Judge.
What's the charge that he's on?
Unauthorized use of and respective of property.
All right. So who is here on the possession with intent to deliver 4 to 200 grams?
Possession as well, Judge.
Yeah, I have that. Are referring to a case number 2025 CR 009295.
Yes.
That would be me. That's the one of the 12 that I'm on.
All right. So you're on that one.
Yes, sir. And I'm already discussed with Mr. Ramos. And I believe Mr. Wolf, we're okay with because Mr. Ramos has the case with the earliest offense date. So I'm not trying to volunteer him, but we're perfectly.
Next up, Quentin Lee Francis plea hearing. Sounds routine? Not quite. The judge is about to run through a legal checklist just as critical as the sentence. Miss a single yes, ma'am, or here, and the whole deal could collapse.
So are you on the first degree, Will?
I am, Judge.
All right. So do you have any objections?
No, Judge.
All right. Thank you. Thank you. All right. So then if you can get in touch with Mr. Acevedo to have him come back, we'll take up the matters. And Nora, if you'll place him on those, please.
Yes, ma'am.
Who's here on Quentin Lee Francis? And is this for a plea?
Yes.
All right, the court is calling 2025 CR 000574, State versus Quentin Lee Francis. Can I have parties announced?
Megan Galloway for the state.
Charles Bunk for Mr. Francis.
And are you Quentin Francis?
Yes.
Counsel, have you received?
Speak up.
All right, thank you. Counsel, have you received all discovery?
Yes, Judge.
Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Mr. Francis, did you review the application for deferred or community supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Francis, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest, detention in a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Francis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a cap of 6 years in the prison. There's a $2,000 fine. State is opposed to your application. This will run concurrent with 2024 CC 740704, 2025 PF 00232, 2025 PF 29409. The state will take in consideration 2025 PF 00230, 2025 PF 00232, 2025 PF 00233. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is, Judge.
State is at the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to the offenses filed, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offers states one in attachments.
No objection.
All right, did you review the waivers and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to?
Here's the moment of truth. 2 paths, both leading to custody. Option 1, 6 years in prison, flat time. Option 2, 8 years deferred with ISF and intensive probation boot camp. The choice reveals more than preference. It shows your risk tolerance and whether you still believe in redemption.
Jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. How old are you?
20.
All right.
And just like that, the deal is signed. But freedom doesn't come cheap. It's drug tests, community service, classes, GPS tracking, an entire list of restrictions. This is the fine print that comes with freedom.
Something like ISF would be more beneficial to him in the long run than just the jail sanction followed up by outpatient.
All right. So are you waiving PSI?
We will waive PSI, that, Judge.
All right. So these are your choices. These are the only choices you have. There is no other choice. So don't come to me for a third choice. Either choice you make, you're going to end up going into custody. Do you understand?
Yes, ma'am.
So your choice is 6 years in the prison or either I will give you your deferred adjudication, but your deferred adjudication is going to be for 8 years. And then you're going to do time in ISF. Those are your only choices. There are no other choices. So which do you prefer?
Deferred adjudication.
All right. So this is what the court is going to be. There's 8 years deferred adjudication. There's to be no driving until further notice. How far did you go in school?
To the ninth grade. The ninth grade.
Why are you dropping out of school?
I stopped going to school whenever COVID happened. And I just didn't go back.
All right. There's going to be 200 hours of community service restitution. 100 of those hours will be waived if he obtains his GED, some type of trade school or higher level education. And if you're drug tested today, what would the results be?
Negative.
There's going to be regular reporting by Zoom or in person, regular random UAs. There's going to be proof of employment within 45 days of release, no employment as a home health care provider or with minors. There's to be the defensive driving course. Field visits 1 time per month until further notice. There's going to be partial GPS upon release, waive fees, and partial GPS will be for employment and fulfillment of probation conditions only. Taking consideration 2025 PF 00230, 2025 PF 00232, 2025 PF 00233. This is to run concurrent with 2024 CC 740704, 2025 PF 00232, 2025 PF 29409. There's to be a TAP evaluation in custody, follow recommendations, and there's to be ISF probation. Do you want that to be local or not? It's really for cognitive for now.
Local judge.
All right, so there's to be local ISF. And there's a $2,000 fine, and that will be probated. And there's to be no unsupervised contact with minors. All right, is there anything else? Probation? Is there anything else you need from the court to be successful? Mother, is there anything else he needs? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
We can go off the record. Here's the thing. You're 20. You're throwing your life away. You've made your life more difficult than it has to be from doing stupid things. If you would have had an accident in your mother's car and you're not on her insurance, guess who would have had to been paying for that out of pocket? She would have had to been paying for that because she gave you permission to use her vehicle. Do you understand?
Yes, ma'am.
If you continue the way you are continuing, only one or two things going to happen. Either you're going to end up in prison, right? And I don't think you like prison because prison would not be good for you. Do you understand?
Yes, ma'am.
And there are people who are in prison who, some people there just want to do their time. But then there are some people who want to make their time, other people's time as miserable as their time. Do you understand?
Yes, ma'am.
So you better get your life together. If not, you're going to end up in prison. Do you understand?
Yes, ma'am.
All right. Good luck to you.